Good. All right. Well, good morning, everyone. And my name is Leo Alberigi. I've been an elder law attorney now for almost 27 years and recently been licensed in Texas. So now licensed in California and Texas. And just want to reiterate that this presentation is for informational purposes only. Please, no attorney-client relationship will result from this presentation. A little background about myself. Been happily married now for almost 32 years. My wife and I have 6 children, 3 of which were adopted from China, 2 girls and 1 boy. And the age range on that is the oldest is 31. The youngest is 14, soon to be 15. Last year we had a puppy, a baby Aussie. Is now 14 months old or 60 months old. So for those of you young parents who went through sleep deprivation either recently or last year, I can relate to that. And so I'd like to go into more of that, but if you want to know more about my background, schedule one-to-one. All right, on to the presentation. Heirs and omissions, this catchy little title I thought about because as a professional, we have to carry heirs and omissions insurance. And you can think of this talk as heirs and omissions insurance or insurance, because I'm going to point out some red flag areas, either for yourselves, perhaps it's your parents, or some other relatives and friends to look out for. And if anything comes up, there's questions, always available to give complimentary appointments. And if I can't help them out, I can refer them to a professional who can. So with that being said, let's go on to the next slide. All right. Now, hard to believe in this day of age, I still would say that 30% to 35% of my practice, I'm dealing with a decedent's estate that had no written estate plan. And it ranges in age. It can be young adults who unexpectedly died. It can also be those who are advanced in years. And I can't stress this enough that it's probably one of the worst things that can happen. Now, there's a little trick question out there for estate planners, and they'll ask, well, do you have an estate plan? You say, well, no, actually you do. In the state of California and in Texas, you do have an estate plan, and the legislature's made one for you if you don't do it. And as a result, one of the red flags is you can have unintended heirs. And one particular situation is if you had if you were married and your spouse died less than 15 years ago, but at the time you had community property interests in real property, guess what? If you die without an estate plan, that deceased spouse's children, in other words, your stepchildren, can actually have an interest in the real property that you weren't aware of. And that can create all kinds of issues. As a matter of fact, here in Texas, if you die without an estate plan and you're presently married, your stepchildren can get a present interest, and you get a life estate and you get partial interest. But now, again, unintended heirs have a present and current interest because you fail to put something in writing. Other red flags for you, those of you who have young kids, or you have grandparents who have children who have, you have young grandchildren. This is something I can't stress enough. It's one of the hardest things sometimes for young couples to wrap their minds around, but you do need to nominate guardians for your minor children. And it's not necessarily easy because you're looking for someone to replace yourself. Well, there's no one like you, and you're not going to have someone that's going to perfectly copy your beliefs, how you want to parent. But you try to choose the best alternative, and sometimes you can't come to an agreement on that. Well, if you don't, then you open it up for someone that you did not intend and is not desired to be raising your kids in case there's an unforeseeable intervening event that you're no longer with us. So again, I can't stress enough for you young parents, please get a will in place, get an estate plan in place so that you have a person to take over for you to finish raising your kids in the event you cannot. Other unintended consequences are Executors, administrators, usually you have a person or you have persons in mind that would take over, not only if you pass away, but also if your mind goes scalopoli, maybe you have an illness. I know some friends who had long-term COVID. They didn't die, but they were incapacitated for, a couple months or 4 months in one case. And in that case, who's going to pay the bills? Who's going to manage the household? Well, if you don't name anyone, then you got a conservatorship that will ensue. And that's someone that's unintended and or potentially unintended that can start managing your household. So you want to have an estate plan. You want to have powers of attorney. Uh, in terms of executorship or trustees, please name someone. Don't leave it, in the ether somewhere where you hope someone will come forth that will do the right thing. You're the one who's in charge, and you need to select your go-to person. Next. Unintended heir, as I just mentioned this, if you don't have a current power of attorney for finances or even healthcare directive, you can have a unintended heirs conservator. There's a case about 7 years ago out of San Francisco where I think it was a great granddaughter-in-law took over for her great uncle. She came from the New York area, and because great uncle didn't have any estate planning in place, this particular great niece-in-law was able to take over and control his assets. Unfortunately, she abused the situation, and Richard was just talking about loans. She decided to take a loan out and basically spend the money on herself. She got into the bank accounts. She went on several trips to Europe and I think one was the Bahamas. And by the time the courts were able to intervene, about 75% of the retirement for this great uncle was depleted. So again, you want to make sure that you name the person you want in case you become incapacitated. Believe it or not, this is an area where it's become an area of friction. If you don't have a healthcare directive, that can lead to what's called disposition litigation. What's that? We're basically fighting over how the remains are going to be disposed of. It seems silly, and it seems like a reality show, but it actually is something that happens from time to time. And as a result of not having a healthcare directive, you can have an undesirable and unintended person who believe they are in charge of how you're going to be disposed of. There's a saying here, when it comes to estate planning and a person dying or is incapacitated, the cream rises to the top and the sewer sometimes requires the cop. What do I mean by that? There was a case about 4 years ago where this elderly woman died. And unfortunately, during her latter years, her daughter and son-in-law moved in. Son-in-law had some chemical dependency issues and basically tried to gatekeep the situation and basically thought he was in charge. And there was the, shall we say, heated discussion regarding the disposition of the body. And it got so bad that apparently the quote was from my funeral director friend said that, look, I'm tired of this. Let's just bury the bitch. Okay. Or actually, excuse me, burn the bitch is what he said. And that's not the kind of person you want in charge of handling your affairs, let alone handling your final disposition. Then there's this situation. Those people who want to be fair to everyone, they try to have all the kids make unified decisions. It doesn't work. We've seen Congress in action or inaction, and there's the exception to the rule. You can have multiple children or individuals be, they can be in charge, but generally speaking, doesn't work, and it can be very costly. So our advice in that situation is you have a go-to person that will make the decisions. That way you avoid Congress and you don't have delays in decision making. Also, when it comes to picking someone, it's necessary for the person to pick someone that's going to take into consideration their availability, their organization skills. In other words, can they keep records, especially financial accounts? Do they have a thick skin? because they may be the target of verbal attacks and accusations. Are they resourceful? So these are things you want to take in consideration when you're picking someone to manage your affairs. Sometimes selecting a private or independent fiduciary is your best bet because there's just too much friction depending on the family fabric. Out-of-date documents. This is another red flag, and a common situation that happens here is an omitted spouse or child. And in that particular case, what happens is that you may have a spouse or child that takes an interest that's, and under California law, they take an intestate interest, and that may not be the interest you wanted to convey. So unfortunately, if you don't put it in writing, too bad, California rule or law will take over, and that particular spouse or child will receive that interest. Life insurance policies. Now, under California law, if you do divorce your spouse, then that divorced spouse is automatically excluded or precluded from being an heir. However, there are exceptions, one of which is a life insurance policy. I have an example about Jack and Jill, but because of interest time, I'm going to move on here. Language, if you do have a written estate plan, especially in a trust, be careful about the language used about who your heirs are. Generally, there's two categories. One is called per stirpes, by right of representation. And that generally what that means is by the class. If you want your kids to be the beneficiaries, you'll say to my kids by right of representation or per stirpes by right of representation. However, I also seen language about per issue per capita, which means head count. So let me give you a simple example of how that works. Let's say that you have a parent who has 4 children, 1 predeceases. Under per stirpes by right of representation, the 4 kids would receive 25%. However, the child who predeceased the trustor, that 25% will be split between that person's 2 children, okay? However, when it comes to per capita, that will change. So not only do we have the 3 surviving children, but we have the 2 grandchildren in this case. So that estate will be split 5 ways per capita. So be careful about the language that's being used. Make sure it's conveyed exactly how you want things to be distributed. Omitting backup heirs. Trustors, the trustor can execute a trust or will with no backup beneficiary, or in this case, a backup trustee or so forth. We want to avoid that. I always recommend that you have at least 2 backups. And the reason for this is, again, unforeseen circumstances can happen, and we don't want to have to go to court to pay extra money to appoint someone who can easily have you or your friend or whoever name that person. Okay, and I see that looks like I'm out of time here because my slideshow is gone. But these are just some red flags, and I'm happy to review the estate plan for you or your referral, and I give complimentary appointments to help go over that and drop a plan to action. Thank you very much. Have a great week, everyone, and take care.
Thank you very much, Leo and Richard, both